Hello again. Let's get you across the latest now from the Mbenenge Tribunal, where expert witness Lisa Vetten has again tried to clarify that her analysis of the exchanges between the judge's secretary, Andiswa Mengo, and the High Court President, well, the Eastern Cape Judge President, that is, Selby Mbenenge, did not seek to patronise the complainant. Vetten was under cross-examination in this landmark probe that's looking into a complaint of sexual harassment against the top judge.
I think you're misinterpreting what I mean but when I say childlike. And I repeat again that I'm talking about a position in relation to the judge. I'm not talking about somebody who's actually a child, should be thought of as a child. It's more like positions of authority.
Yes, no.
It's not about people's mental capacity. It's not about their abilities. It's about the degree of respect or deference you are expected to show somebody when you are positioned in a particular role. It's not that that person is a child and you treat them as a child.
If you found out, and I'm not going to make it specific, if you found out that a complainant, not the complainant, a complainant has a history of belligerence towards a senior person, would you still hold the same view?
It would depend. You'd want to know about that history. You'd want to know how it unfolded. You would have to take a whole lot of factors into account.
What would you take into effect? If you say someone fears authority, and I demonstrate to you that that complainant actually does not fear authority by action, does not, would it change how you look at them? Would it change how your generalized opinion that they fear authority, maybe that's why they don't say certain things?
It would depend on the circumstances.
Let's get you more on the Mbenenge Tribunal. Bring in SABC News reporter Canny Mphanga, who spent the day listening in to those proceedings. Canny with us in studio now. Canny, good to see you. Let's start with more actually on the exchanges between Advocate Sikhakhane appearing for the judge and Lisa Vetten, because again we circled around the issue of consent and context, but also a lot of pushback between the two of them in terms of those very definitions.
So indeed, Lisa Vetten, as a researcher, she's there to provide context regarding the nuances of sexual harassment, and I think that engagement speaks to the heart of what she's trying to convey to the tribunal, is that it is a complex issue. It's not black or white. A victim may not react in an ideal manner, may not behave in an ideal manner in the face of such conduct. They may employ strategies which she's tried to explain are means in order to manage the situation. You may remember with the case of Andiswa Mengo, there's so many elements at play. It's such a layered case, this particular case of Andiswa Mengo and the judge president. But of course, in her matter, we are seeing a sexual harassment probe where she does engage in some of the text messages. Remember, the analysis of Lisa Vetten is that she was not a willing participant and that she employed strategies to better manage the situation, because when you're dealing with a junior and a senior, it's not quite easy to directly say no because of the consequences that might follow. However, Mbenenge's counsel has not accepted this version, stating that it's sympathetic to the complainant. It does not holistically include how the judge president may have perceived the interactions between them, and it seeks to I guess the term used was patronise her and create a figure of a childlike person who
basically infantilise her in a sense.
Yes, who feared authority, and the example is used as how she related to the court manager, or at least on the record how it stated how she related to the court manager. But again, that speaks to Lisa Vetten's point that we don't relate to one another the same based on position and status. How you may relate to your fellow colleague or your fellow EP, for example, may not be the same way that you relate to the CEO. So that is what the point of the conversation that she's trying to drive home, that it's layered, it's quite nuanced, it's about power imbalances. Some people don't enjoy the same authority or status, and that even where power dynamics exist, they can shift in this situation or in this scenario where if I'm dealing with you, for example, the power dynamics could be much different. So that was basically the back and forth regarding Lisa Vetten's evidence. Of course, it's up to the tribunal if they decide whether they're going to accept that expert testimony or not.
On that point then, is it Advocate Sikhakhane's point at this stage that her testimony or her evidence should in fact be rejected, because he has accused her of bias and basically, and I'm paraphrasing here, cherry picking her evidence and how she's presented it.
I think the argument was that it was deficient and that it's not helpful to the tribunal because it takes a certain position and doesn't include the judge president's version of events or how he may have possibly seen or responded to those messages. It also doesn't take into the cultural context between the pair and how the messages could be read or the practice of courting could be read between the two of them. But once again, she has emphasized that her job was to analyze them in the context of a workplace environment and what is appropriate and not appropriate in a workplace environment. But of course, it's a complex issue. And once you add all those elements together and how layered it is, it does become difficult to blur the lines.
Just on that, Canny, does this process, the tribunal, seek then to draw a distinction whether the judge is guilty of sexual harassment, that even if it was quote unquote courting, he was a superior, a married superior at that, who would have been pursuing what would be, at least at a very basic level, an inappropriate one?
I don't think it's the tribunal's concern what his personal marital status is. I think the complaint really is about a junior secretary alleging that she was sexually harassed by a judge president. Now you're looking at the conduct of the judge president, and the ultimate assessment is whether it is fit of that someone holding a role that he holds, and if it does, affect the judiciary and all those other elements that a judicial inquiry will look at. This is a tribunal, so it's not a court of law. It's a fact-finding body, which will gather those evidence and come up with the reports that will be given to the JSC, and then they will ultimately come up with that sanction for the judge president. Of course, if he's found guilty of gross misconduct, then you are dealing with a serious offense, which is now in the realm of possible impeachment, and that is the next process that could follow. However, what the Judicial Conduct Tribunal is doing is that they are gathering the facts, assessing the facts and the evidence. They'll come up with their report, and it's really about his fitness to hold judicial office, not so much about the personal elements, but is he fit to carry that role in light of these kinds of allegations? Of course, it's a very serious allegation, and if it is a gross misconduct finding, then of course you're dealing with the realm of impeachment, but there could be lesser sanctions, and there is a possibility of being cleared as well.
And I want to ask you just lastly, when do we expect to hear from the judge president, and also the decision today taken by the tribunal that Ms. Mengo's side or her legal team cannot in fact cross-examine the judge's witnesses?
Well, that is a part of the legislation that governs these types of processes. That is the JSC Act. It is common practice that the respondent, if they take the stand, they're cross-examined by the evidence leader, not the complainant's counsel. There have been a lot of allowances that have been made in this particular tribunal because of the nature of the tribunal. And then, of course, the chairperson himself enjoys that discretionary power to allow certain things to happen in the tribunal in the name of fairness. However, they couldn't, outside of the rules and the legislation, allow such a request to be granted. So the alternative for Mengo's counsel is that when the opportunity for cross-examination arises, because it will, we know that there are 3 witnesses prior to the judge president, then they can consult with the evidence leader should they feel that there are issues that have not been discussed efficiently during that cross-examination process.
Canny Mphanga, thank you very much for that. Canny, by the way, is keeping an eye on the Mbenenge Tribunal, so she's the person to follow even on social media for perhaps a blow-by-blow account of what's going on at the tribunal.